Or internet, sometimes you can hear that legality or legal object. And for a contract to be valid and enforceable, right, it must be formed for a legal purpose. Right? We mentioned briefly in the first few classes when we discuss the essential elements for a contract to be valid. So if a contract to do something that is prohibited by federal or state statutory law, it is illegal and such as void from the outset and therefore unenforceable. And additionally, a contract to commit any tortious act, such as an agreement to engage in fraudulent misrepresentation, is contrary to public policy and therefore illegal and enforceable, right? So we will look at the two categories of illegality, contracts contrary to statutes and contract contrary to public policy in turn. First one, right? Contracts contrary to statute. So statutes or the law often set forth rules specifying which terms and clauses may be included in contracts and which are prohibited, right? So there are some in the contracts to perform an activity that is prohibited by statute are void. So we're going to look at different ways in which contracts may be contrary to statute and thus illegal. Okay, so the first one would be usury law. What does it mean by usury laws, everyone? If you read the textbook already, you might know it. What does it mean when we say usury? Usury. What do we mean by usury laws? setting the upper limit on the interest rate which can be charged on loan. Yep, right. So usually laws set an upper limit on an annual interest rate that can be charged on certain types of loans. And this the limits vary from state to state. And if the lenders who charge a higher rate than the state limit are guilty of usury. Okay, usury. And these laws are intended to protect unsophisticated borrowers from loan sharks and others who charge exorbitant rates of interest. Right, charge crazy rate, right? Another one would be contracts committed crime. Right? This one is very, very clear, and I also used this as an example a few times ago, a few times before, right? So we don't need to discuss it anymore. Gambling, right, is also considered as contrary to the statute in some states. Okay. Next one. The second one would be contracts contrary to public policy, right? So even though some people may say that the contracts are involved private parties, right? Some are not enforceable because negative impact they would have on a society, even though it's between two people, but it should not affect, it should not, how can I say, reversely affect the society, okay? And if and these contracts are said to be contrary to public policy, right? You can see there are different examples like human trafficking. You sell people, right? It's usually kids, children, and women, right? Human trafficking, right? Or it could be that, you know, contracts that prohibits marriage. Right? We cannot say like, oh, if I sell a baby to you, it's between you and I, right? It's also this is obviously contrary to the public policy. This is inhumane, right? So let's look at some special business contracts and licensing statutes as well. Okay, so the first one could be contract in restraint of, hold on, give me a second. Okay, so what does it mean when contracts in restraint of trade? So as the name might suggest, contracts in restraint of trade, right? Or sometimes they call it anti-competitive agreements, usually adversely affect the public policy that favors competition in the economy, right? Typically, such contracts also violate one or more federal or state antitrust statutes, okay? And an exception is recognized when the restraint of trade is reasonable and contain any secondary or subordinate clause in the contract. Okay, so you can read more about this in the textbook, where they also have some like covenant not to compete and the sale of an ongoing business. Okay. Licensing statutes. What does it mean when we say licensing statute. Right? So a licensing statute requires a person or business to obtain a license from the government prior to engaging in the specific occupation or activity. Right? So for example, a state law provides that a legal services can be provided only by lawyers who have graduated from law school and passed the appropriate law exam, bar exam, right? So if suppose a first year law school student, right, agree to draft a contract for B for a $350 fee, right? And because A is not a licensed is not a licensed lawyer, right? A is not licensed to provide any legal services. A has violated a regulatory statute, and she cannot enforce the contract and recover from B. And B, even though received services by having his contract drafted, does not have to pay A the amount of the agreed amount of money. Okay? That is an example of licensing statute. And the last one that the book also points out is exculpatory or exclusion clauses. Okay. So exculpatory clause is a contract provision that relieves one or both of the parties to a contract from tort or liability for ordinary negligence, right? Also, sometimes we call it as release of a liable clause. Right, so usually when you involve in any participate in any kind of risky sport, they all usually ask you to sign an agreement, right? Contain an exculpatory clause that relieve um, the host, right? The one who get you to participate in that sport of any liability. So if you though you would like to swim in the sea, right? And there's an activity, whatever, that there's a company that have that activity. And so if you want to swim in specific area of the sea, of the ocean, and then you will sign a contract having an exculpatory clause with the center with the company, right? And so after you receiving any proper instruction and you go to that area of the ocean to swim, so if you have any injury or even if any injury, so you can you cannot sue the company for any damages because the court would usually enforce this exculpatory clause and reasoning that swimming in the ocean was a voluntary choice and it did not involve an essential service, right? So more details or more examples can be found in the textbook, right? So to review an effect of illegality, very straightforward. You cannot sue for any non-performance. You generally refuse to enforce, the court generally refuse to enforce or rescind an illegal contract, and the court will generally leave the parties where it finds them. Okay. So now to summarize what we have discussed so far regarding legality, right? So now let's look at this one together. See. So there are two groups. Of There are 12 boxes. Okay. Let's look at this. Okay. This is so let's look at number one, right? A. You will match the numbers to the letters, right? So this is just a review. Okay. You can do this in a group, that would be fine, or you can do this individually. I don't mind. Right. So this is to uh, GKL. Right. Okay, so let's match. This is like an overview of the what as discussing legality, right? Contract legality, so or illegality or legal subject, whatever name you call it. Please match the numbers to the letters. Okay, so let's spend the next 10 minutes, okay, until 3:22 to do this one. All right, it help you to review what we have discussed so far, so you don't have to go home and study it. Okay, and I will go over. You can be in groups. You can have the group chat with your friends. It's fine, or you can you can get it done individually. I don't mind. Okay, so let's hear some of your responses then. So for number one and number two, the two big categories, what would you for number one, what is your choice?
May I answer that?
Yeah, sure, of course.
For
Right?
yes.
Yeah.
For number one, I choose A.
Okay, hold on, give me a sec. For number one, you choose
A.
yep. Okay, choose another color. A. Okay, and number two.
Two is L.
L. Okay. Right. Thank you. How about the? Can you do the rest?
Yes.
Sure. All right. So 3, 4, 3, 4, 5, 6.
3, 4, 5, 6. I got B, F, E, and G.
G.
G. Yes.
Okay. So all right. B. All right. F. E. G.
G.
Okay.
Yes.
Right. And first, of course, the rest will be the rest, right?
Yes.
All right. So let's look at each one by one. Number one. So A and L, right? Agree, right? This is the two big categories, contrary to statute and contrary to public policy, right? Agree. 3B, right? Yep. This one is another the way to say usury laws, right? We discussed at the beginning. So B, correct. F could be commit a crime. Agree, right? Because always illegal, right? And while usury loans is illegal if the interest rate exceed the legal limit, right? E was E, commit a tort, right? Commit a tort, as I mentioned in the beginning, maybe it was very quick because it's not very quick, but it was not separated from the two categories at the beginning, at like the introduction. So maybe you did not hear very well. So it was not very clear to you guys, but commit contracts to commit a tort, right, is actually in here, right? In contrary to the public policy. Right? When I say like by the beginning, a contract commits a tortious act, such as an agreement to engage in any fraudulent misrepresentation contrary to the public policy and therefore illegal and irresponsible. Okay, so this one would be F, not F, I'm sorry, E, right? E, not E, and the laws of EG, contracts by unlicensed person. Okay, contract by unlicensed person, definitely this one is under the column number one, right? So what is, anyone can give me another letter for one of the situations that contracts contrary to the statute. Thanks, Will. Anyone else? What else that also contrary to the statute that we already mentioned, pointed out? Maybe it is not, where is it? It could be gambling contract, okay? Because under the US law, it is illegal depending on the state statute, right? So it is a little bit different mindset from Vietnam, because in Vietnam we have uniform law, right, from the provincial level to the national. But in the US, they have two different systems, right? The state system and the federal system. So it's sometimes it's a little bit confused, because sometimes one thing is illegal in one state may be illegal in another state. So that's why in this case, gambling contracts is illegal depending on the state statute, right? And for the rest, you would just in. So contract in restraint of trade, right? C, this is obvious. We mentioned that contracts to commit the tort, unconscionable contract, which is a contract that must be so unfair as to be oppressive. We will discuss this later on in greater detail, right? So this would be okay, right? And adhesion contract. Right? What does it mean, adhesion contract? What name of this adhesion contract? What do we mean by adhesion? What does it mean by adhesion contract, guys? An adhesion contract, as we may pointed out before, which is a contract that like have a formal, pre-printed contract already, right? So it may be unenforceable if entered into because of one party superior bargaining power compared to the others, right? So let's here. So this is self-sharing. Screen share. Okay. So do you have any questions so far for this part? Otherwise, let's move on. So, and this is some exceptions to the general rule, right? Very straightforward. So you can read more by yourself, right? Regarding the illegality. Okay, so quick question. Have you read the Vietnamese law yet? Okay, silence. If you have not, right, don't worry. If you have not, please do read, because I don't want you to wait until the last minute to read that. We're not sure how the format of the final exam this semester, right, because we actually come back to school already. So it might be in class, it may be offline. So just prepare in advance if you can, so you don't have to be shocked later on. Okay. The slide is actually just the guidance for you to walk you through all the legal issue if you have any problems to navigate that. All right, next one. Let's move to chapter number 3, legal defense to enforcement of the contract. We briefly discussed that before, but we will how can I say, explain the concept in more detail in this chapter. The first part, we're gonna discuss lack of genuine assent and unconscionable conduct. under legal defense to enforcement of a contract under the US law. Genuine assent, as the name suggested, right? It means that assent is one of the requirement, right, for a contract to be valid under the US law. So genuine assent means what? Can you guess by the name itself? What do we mean by genuine assent? So genuine assent is, I just answered that to save time, right? Is the requirement that a party's assent to a contract to be genuine, to be voluntary, right? It's not under any specific reasons that they have to be a contract to the party without their will, okay? So, and the contract may not be enforced if the assent of one or both of the parties to the contract was not genuine or real. Okay? And the court may permit the rescission of contract based on the equitable doctrine of undue influence. Right? And we will discuss some issues related to genuine assent in the next slides. So in some situations, genuine assent may be lacking, right, due to mistake, misrepresentation, duress, or undue influence. So first, let's look at mistakes. So mistake is a word that everyone should have known, right? So it means a mistake. It means that when one or both of the parties to a contract have an erroneous belief about a subject matter, value, or some other aspect of the contract. And, right, a mistake can be made mutually or unilaterally. Okay? So we have mutual mistake or unilateral mistake. Okay, and the law permits rescission of some contracts that made in mistake. Right. So let's first look at unilateral contract. Unilateral mistake. Okay. Like the name, right? Unilateral is not only one side, right? So unilateral mistake is made by one of the parties, right? And in general, it does not give the mistaken party any right to relief from the contract. And the contract is usually enforceable, right? The contract is usually enforceable. However, relief would be granted if, right, number one, the other party of the contract knows or should have known that the mistake was made, right? The mistake of fact. And number two is that due to any substantial mathematical mistake in addition, subtraction, division, or multiplication, and was made inadvertently without gross extreme negligence. All right. And the mistake is so serious that enforcing the contract would be unconscionable. Okay, so that is about unilateral mistake. And let's look at mutual mistake. In mutual mistake, they categorize it into mutual mistake of fact and mutual mistake of value, right? So the mutual mistake of fact means that when both parties mutually misunderstanding concerning a material fact of the transaction of the contract. Okay? So the contract in this, when both parties are mistaken about the same material fact, the contract can be rescinded by either party. Okay, And a word or a term in a contract may be subject to more than one reasonable interpretation. And if the parties to the contract attach materially different meaning to the term, the court may allow the contract to be rescinded because there has been no true meeting of the minds. Okay. And mutual mistake of value, right? This one is so if a mistake concerns the future market value or quality of the object of the contract, then the mistake is one of and the mistake is one of value, then the contract normally is enforceable, right? Because the value is variable and depending on the time, the place, the circumstances, right, the same item may worth considerably different amount. So if we allowed the contract to be rescinded by the party who got worst of the deal, right, most all contract would later on be rescinded. Right? So now let's look at an examples. Let's look at the example together. I will walk through the contents very quickly because you have the book already. You will read that and you have a slide. I will give you example to clarify, right? To make you understand the materials better. That's why I always stress that we should, and it is also recommended by the Division of Commercial Law, is that student must read the material before coming to class. So at least you have an idea what we are discussing, and you just pay attention to things that I will share that might not be included in the textbook. Okay. So let's look at two examples. Example number one, right? Example number one, right? E intended to sell her iPhone, right? To C at the price of 250, right? And so E sends C an email. However, E mistakenly keys in the price is 150, right? So, and C see that, oh, it's so cheap. C immediately send back and say, yes, I accept your offer. So in this case, can E, I mean, let's ask an is E bound by the contract? Right. Once is an offer, this is an acceptance, we have a contract here already, right? K means contract, huh? So the question is E bound by the contract? Okay. 250. Okay. Two. Example number two. Question, scenario number two, right? So A, cleaning the house, right? And A saw a painting thing that A does not understand, right? And then B actually thinks that, oh, the painting was very cute. So A offered to sell B the painting at the price of 100 US dollar. And B gladly accepted, right? So there's a contract. Later on, right? No one knows what is that painting at that time, right? Later on, I realized that the painting actually by Picasso, right? Which worth millions of US dollar. Let's say it worth 3 million, right? In this case, the question is, can Can A cover the painting? Can A recover the painting? Right? Is it clear, everyone? Do you have any question for the two examples? All right, so let's think by yourself, or you want to be with your classmate to discuss these two cases. Okay, maybe you don't say anything, so I'll let you guys do it by yourself. Okay, let's spend a few minutes to think of this. Like I say, 9 minutes. We will get back at 3:50. Okay, this is the very simple, basic cases. So just spend some brain power to try to figure out the answer. Right? So the first question would be, is E bound by the contract? And the second question is, can A actually recover the painting that's sold to B already? Okay, so for scenario number one, what do you think? Is E bound by the contract to sell the iPhone to C at the price of 150?
Miss,
Yes.
I think that E still bound by the contract because E in here in this situation, E email to C
Mhm.
with that price. That means that it's already know of the price. That does mean it doesn't happen any mathematical error in here. Therefore, the relief can be granted. So E still bound to the contract with C. Therefore, just like I think that E deliberately sent that price to C, not because of any mistake at all.
Okay, thank you. So you think that E, in conclusion, you think that E is bound to the contract, right? Thanks for.
Yes.
And because
And
of, well, what is the legal basis for that?
I think that because of the unilateral
Unilateral what?
unilateral mistake.
Okay, thanks for unilateral mistake. Good.
No.
Right. Anyone else? Do you have a different ideas from Phụng? Or you agree with her? No one. All right. So yes, agree. Right. So in this case, even though E intended to sell her iPhone for 250, but she has made a unilateral mistake and is bound by the contract to sell it to C for 150. Right? So very good answer. Thanks for. Number two. How about number two, guys? How about number two?
And for number two, I think that name A. A can recover for the pain.
Can or cannot?
A can.
I can. Okay, I can recover. All right.
Because in this situation, maybe both parties know the object of the contract, which is the painting, and both of them are mistake about the value of the painting. Maybe B doesn't
Okay.
know the price of it, and they just think, oh, that's cute, that's all.
Yeah. Yeah. Of course. B didn't know. Both of them did not know the value of the painting at the time of purchase.
Yes. So at that time, maybe the A can recover the painting.
A can recover the
And
painting.
the mutual mistake of value.
You mean it means it is possible, right, for A to recover?
Yes, but it may be impossible if we know the price of the painting.
Okay, thank you. All right, so you think that it's the mistake and the mutual mistake of value, and A can recover. Okay, thank you. I think so. Anyone else? Do you have different idea? Okay, so in this case, right? In this case, Phụng gave the good, the correct legal basis, that the rule, which is the mutual mistake of value, right? But Phụng, please pay attention to it a little bit. Look at the slide. You can see that here. Let me. I think that you because we have just studied, so maybe you have not. But you got the way that you analyze it is correct. But maybe here the contract is enforceable, right? Where is it? Here, right? You see the second bullet point, right? So it means that it means that the contract between A and what is the people forgot, between the two people, right, is enforceable. It means that the seller cannot recover, cannot get back the item, because no relief for the party that got the worst of the deal. But in this case, the seller is the party that got the worst of the deal, right? And you see the second bullet point. Because by rule different, by most later been extended, because buy something at this moment, and then if the recover from the contract, then most of the transaction will not be completed. Okay, so just a little bit, just a small one. Okay, so the answer, your rationale is correct. This is the mutual mistake of value. Both party did not know how valuable the painting was at the time of purchasing, right? So under the principle of genuine consent, or specifically mutual mistake of value, then the contract is enforceable. Therefore, the seller cannot recover the painting. All right. Good job, though. Okay. Next one. We're gonna move to misrepresentation. Okay, we look at fraudulent misrepresentation, negligent misrepresentation, and innocent misrepresentation. Okay. First, fraudulent misrepresentation. Right? Do you hear the word fraud a lot of time? So this an intentional misrepresentation is also commonly referred as the fraudulent misrepresentation of fraud. Okay, so what is that? This is an event that occurs when one person consciously decides to induce another to rely and act on a misrepresentation. Okay. So, in order to prove fraud, there are certain elements must be shown. So the first one is that the misrepresentation of a material fact must occur. There must be an intent to deceive. The innocent party must justifiably rely on the misrepresentation, and to collect damages, the party must have been harmed as a result of the misrepresentation. Okay. Okay, so now let's look at different types of fraud. Right? They actually mentioned this in the textbook. So, and also the information is presented on the slide. So please first read the slide, and I will give you guys some example to illustrate each point. Right? Right. So let's look at the fraud in the exception. Right. For example, if A uh, say to B that this is the contract of the lease, right? And then B actually believe inside, I lease your house, so I rent your house, so this is a lease. And A didn't read inside, but later on, B actually figured out this is a contract, this is an agreement, right? Saying that A agrees to transfer all of B's property to A, right? So this is actually the fraud in the inception. Therefore, the contract is void. Right? And a fraud in inducement. So let's look at this, right? So A say to B that A would like to open a flower shop, right? And would like B to invest in the this investment, okay? This business plan, and B agreed, right? Even though in reality there is no uh, flower shop or anything. We just want to use the, I just want to use whatever the money I receive from me for personal expenses. And B actually relies on a uh, statement and pay and give a 20 million Vietnam dong, right? However, A actually ran away with the money, and this is considered as a fraud in inducement, right? So B has been induced to give A 20 million based on A's misrepresentation of fact. And of course, in this case, B can rescind the contract and recover the money from A if, of course, B can find A and locate the money or the property. Okay. Next one would be fraud by concealment, right? Fraud by concealment. Let's say you buy a car. Okay. Uh, sorry. So like you buy a used car, right, from a used car dealer, and you say that I wanna see all the paperwork related to any repairment that has been made for this car, right? The used car dealer did not give you anything, so you assume that there was no preparation, no repairment, right? The car is in good condition and has never been repaired. So you bought the car, right? Later on, you discover that a car was went through a significant repair, right? Repairment, and that record has been concealed by the company, the dealer, right? So in this case, you can actually sue the dealer for fraud by concealment, right? The word conceal means to hide, right? Next one, silence as misrepresentation. Right? Generally, the parties to the contract don't have to decide. However, if a seller knows, right, a serious potential problem that the buyer cannot like reasonably be expected to discover, then the seller may have a duty to speak. And for example, that defect could, like that defect could not readily be ascertained, right? They had to, the seller must disclose the latent defects, for example, right? And the parties are actually in fiduciary relationship, one of trust, such as partners like physician, patient, attorney, and client. They have a duty to disclose the material facts, and failure to do so may constitute a fraud, right? And misrepresentation of law. And this one, if you read the text, if you read the textbook already, right? Misrepresentation of law ordinarily does not entitle a party to relief from the contract, right? Exception to this rule is that when misrepresenting party is in the profession that is known to require greater knowledge of law than the average citizen possesses. So, for example, if you're about to buy the house, right, and the house owner is actually a lawyer or a real estate broker, so his willful misrepresentation of the area zoning laws properly would constitute a fraud. Like, for example, if you know that the house is within the project to be removed, and then they will make a park there, right? So, and there's no way the normal citizen would know that, right? So, misrepresentation of law, right? In this case, would constitute as fraud. Okay, so if you are a lawyer and you're contracting with a farmer, right, and there's something that not every farmer can know, and you knew and you did not tell your partner, right, your contractual party, the other side, then of course it is considered as fraud. Okay, of course it's going to be very case by case. Okay, so I think let's stop here for now, right? We're going to stop at because if I continue with negligence misrepresentation, then it could be a little bit late, right? So we stop at slide 5, and there are only 2 people participated today, which is for Ngày, right? So the bonus points will go to okay, so do you have any question for today's class? Okay, if you do not, have a good evening and be safe then. I heard that many people are tested for positive COVID, recently. So be careful and I will see you guys next Tuesday. Okay, any question, just feel free to email me. Or
Miss.
Yep.
So we have agreed that we will have a makeup class on 18 March or 2020. Yes.
Thanks a lot. I almost forgot. All right, so it's gonna be from 7 to 10:30. All right, and that day is also your midterm exam. Is it okay?
Yes, I also have a question that will we be doing any presentation?
Yes, but very still because this is gonna be you are final year, so I just don't want to give you a lot of pressure giving COVID and things like that. So instead of making like a very formal presentation, so you just need to so this is happening still. Right, so so we're gonna have how many groups in your class again? Yeah, I forgot.
We have 8 groups.
Okay, 8 groups, and we have how long do we have? 3 hours and a half, right?
Yeah.
So 3 hours meaning 2, 7, 9. So we have 210 minutes. So each group. Okay. All right, so let's see. So you have 8 groups, right? So we have 210 minutes. So I will let say okay, so we have a lot of times, right? So I will give you guys each group will receive the question, okay? The case, right? Each group will have different cases, and you guys will have 40 minutes. 40 minutes to have a group discussion, and after that, right? It means we have 170 left, right?
In the panel, they will introduce
right. So
you how to
okay, so we will have 21 minutes for each group left, right? So each group will have 15 minutes to actually present, but you just need to present the case to your whole class, right? Using IRAC, as I mentioned previously. Right? You're gonna state because they're not gonna know what is the issue of your case. They don't know your case, right? So you're gonna what is the issue of the case, the rules, application, and conclusion, and then you will have, let's say, I say 5 minutes to present, right? I will use timer, okay? So please make me brief because when the 5 minute ends, I will cut you guys, okay? So, and then you will have 10 minutes left, right? For Q&A, right? It can be either from me or from your classmate. I will ask you guys, right, first, and if none of the group member, the team members can answer the question, then I will give a chance for the rest of the class, right? For each person who can answer the question directly and correct, of course, in the midterm, right? I will give that person straightforward 0.2, right? To the midterm exam. Okay, is it clear? If this is your group's question, you have to answer that, right? Because you have 40 minutes to prepare for that issue, right? And then I will ask you question related to the issues that you are covering. For example, your case gonna be related to fraudulent misrepresentation. I will ask some question related to that. And if your group, none of the group member can answer, then I will give the chance to the rest of the class. Anyone from any other groups can answer that question from the other group directly, correctly, will receive 0.2 directly to your midterm. All right. So is it clear? So you have 40 minutes to discuss group working, right? And then you have 10-15 minutes to present and answer. So you do 5 minutes to present a case in a very informal way. You don't need to do it very complicated as long as it is clear, right? And then you will have 10 minutes for Q&A from me and from the class. Do you have any other questions? Is it clear now?
So on the makeup class day, we just need to do this midterm test, but do we have any further lesson, or do we have to study anything else?
Do what? I'm sorry, I lost you. Can you say it again?
Yes, sure. So beside the presentation for the groups, do we have to study anything else on
No.
the makeup class day?
No, I will try to complete everything before that, so you will have as much time as possible to do the midterm, because otherwise it will be shorten the time of your discussion. Of course, if you guys wanna study more and to shorten the discussion time, then I don't have any problem.
I understand.
So do we agree that we just do the midterm on March 18th, right?
So class, if you agree that we will only do the presentation, please raise your hand.
No, it's fine. Yeah, you can just do it within your group, and then you will write me an email to confirm
Okay.
that.
All right, sure.
All right. So because some people may not on the internet, right? So right. We have. Let's see. Give me a second. We have one. We have only one class, one full class on Tuesday, and one like the shorter one on Thursday, right? And then after that, we will do the exam. Okay, so please read the materials and make sure you have a good preparation for the midterm, because it's very, very close. Okay, even I sometimes have a hard time doing some questions, given that it is accumulated all at the same time. So and of course, I want to give you the good grades, so please be prepared. Okay, guys? Any question? Any further questions? All right. Thank you. Now, if you have any question, then or the class have any question, feel free to email me and I will answer you guys as soon as possible. Okay?
Yes, sure.
All right, thank you.